Well, hello and welcome, and let me say a very, very good evening to all my fans up north. For the first time ever, I went to Tamale and Bolga, and I must say I was pleasantly surprised. And I must say, all my northern elite friends, you have really sold the north just too short. It was absolutely adorable, and I can't wait to go back. I really enjoyed it. That was just by the way. But this evening, I think it's a very sad topic we have today. Delta 8 released. I think a fair topic for this show would have been breeding impunity would have been a perfect subtitle for this show. Breeding of impunity. Well, once upon a time, there were some Delta Force who are attached to the MPP. You know, they are sort of vigilante or boys who helped the party in one way or the other. When their party came to power, they felt that, listen, we've helped the party to come to power and therefore we want our fair share like yesterday. They were not happy with certain postings, they were not happy with certain offices, and with impunity, barged into the regional security officer's office and police had to come in. All these went on. Eventually, they had to go to court. In court, again, they barged into court and freed the people who were supposed to be on trial, which has never ever happened in Ghana before. That was a first for us, for people to actually go into a courtroom and demand that, listen, you have no right to try our men who broke the law. That was below the belt. But this had been after presidents and parties and officials had given us an assurance that it is ended. Then in Koforidia, it happened again, and there's this forces and that forces. But eventually, when the case, we hear that the Attorney General from Kumasi says that, listen, I don't want to try the case because there's not enough evidence. You know what? Maybe, they may be right that there isn't enough evidence, but just stand back and look at the whole picture and ask yourself, does it look right? It doesn't look right. And the minority are raising alarm to say, hey, we are not happy. We want the people brought back to court. Let us try them to the fullest and let the law take its course. That's what we are looking at today. But before I introduce my guest, take a quick break, and then when I come back, we'll listen to a few sound bites to set the conversation rolling. My name is Nana Ansakwa, the fourth chief of Akwamwa Dumansan and your favorite TV show host, so you don't want to move.
We're interested in seeing that our clients are not punished for offenses they didn't commit. We maintained right from the onset that they had not committed any offense, and so we were patient and waited for the prosecution to, if there are any proofs or evidence, and they have concluded that there's no evidence. So it's more of a victory for the rule of law and the justice delivery system, and not necessarily a victory for us.
Nale prosequa is a term of art and a legal phrase which means do not prosecute. It means an unwillingness on the part of the Attorney General, and for this matter, the executive, and by extension, the president, not to pursue the matter further. We are not surprised because the decision by the Attorney General is a confirmation of the claim by leading members of the New Patriotic Party at the time the lawless action by Delta forces that the culprits will be set free, and they are indeed being set free through the state intervention and the Attorney General filing the Nale prosequa. We are of the view that the government is pandering to partisan pressures at the cost of justice delivery in our country and at the peril of demonstrating respect for the rule of law and respect for an important organ of state, the judiciary. And this can undermine the independence of the judiciary. And distinguished ladies and gentlemen of the press, I'd like to draw your attention to Article 296A and B, but for emphasis for this press conference, we will emphasize 296B, which is on the exercise of discretionary power. Where in this Constitution or in any other law, discretionary power is vested in any person or authority. So the person or authority here can be referring to the President or the Attorney General acting on behalf of the President. Article 296, which is constitutional, provides that the discretionary power shall be deemed to imply a duty to be fair and candid. We do not think, and it is our firm belief, that this is an unfair interference in the judicial process and an utter disrespect to the judicial organ of state. Article 296B emphasizes, and again I quote, the exercise of the discretionary power shall not be arbitrary, capricious, or biased. It is biased because it is one of their own, an activist of the New Patriotic Party. Arbitrary because the courts will seldom initiate this, and the court will not willingly proceed on that because it will be improper to do so. Capricious because they have pandered to a partisan pressure. Free our vigilante, violent group, even if they are creating fear and panic in the operation of the law. We consider the entry of the null prosecutor as a gross abuse of discretionary power, simplicity, and we call on the President to demonstrate leadership. And many of you may want to refer to President Akufo-Addo's inaugural speech, what he said about the rule of law, and what he said about upholding and respecting fundamental human rights. The judge that was intimidated have a right to life and have a right to freely work in an environment that is secured and in an environment that assures her of her ability to discharge justice without fear or favor.
Our system is the acquisitorial system. And when we talk of the acquisitorial system, what it means is that at all times in material, in criminal prosecution, the burden of proof is on the prosecution.
Okay.
And that the prosecution must discharge that burden to a certain point, which will warrant the judge or the court to call upon the defense to open their defense. When the prosecution is unable to prove a case, whether prosecution case is discredited through cross-examination, or the prosecution's case is very weak, or the prosecution's case material witnesses cannot be assembled by the prosecution, the law is that the prosecution has not succeeded in establishing a prima facie case.
Okay.
Now, in this particular case, what the state is saying that they've had the opportunity to consider the witness statement of the witnesses, those who are going to give evidence for the prosecution. Now, they've looked at it very well, but they've realized that they are not material witnesses whose evidence can let the prosecution discharge the burden of proof placed on the prosecution. And therefore, they are to be discharged. It's a basic, simple, rudimentary legal principle. It is the investigator who will tender the video. So you need prosecution witnesses. From the statement given by the prosecution witnesses to the investigator, they are contradictory. They don't come out to establish any prima facie case against the accused person.
I see.
And therefore, you cannot just get up to go and then screen the video. There must be a prosecution witness who will testify before the investigator. It is the investigator who is going to testify in court, and then you will tender the video. But why the other prosecution witnesses? You look at the merit or the substance of the evidence they are going to lay in court, and you think that it is not weighty I mean, so this is going to be discredited. They don't sound like convention. That prosecution cannot go on.
Well, so you know what we are talking about in premises to set the conversation rolling. With me in the studio is Roxanne Dafiapekpo, who is a ranking member on Constitution and Legal Affairs in the House of Parliament, and also an honorable member of Parliament for South Dai. And you're welcome.
Thank you, my brother.
Roxanne, thank you very much. And we find all our, Roxanne's the first timer, so it's a bottle of schnapp for all our first timers are fine. My viewers and I, we find all our first time.
I'm privileged. This is a special interview.
Roxanne, Delta Force released, Attorney General says, listen, I don't have enough evidence and therefore I can't go on. Minority kicks off to say, no, we think there is interference. But if Attorney General hasn't got evidence, how do we move forward?
Yes, let me seize the opportunity to wish my constituents and Peki, Kweve, Tongo, Bali, from Chupukofe to Ajibwe, good evening to the people in the Volta region.
We have a lot of viewers there.
Yes, and to the generality of the public, especially Agabefi in Achmota. She's watching. It's a very sad day for the Republic, the whole Republic, to say that they could not garner sufficient evidence to even make a prima facie case against the 9 accused persons in this matter. It is 1 Abbas Caesar and 8 others. So there are 9. I think the 9th accused person is supposedly at large. You know, if you have been in court before, oftentimes when criminal matters are called, and I've been a defense attorney in hundreds of cases, the normal rendition of the prosecution, you know, normally done by the police, if it's not a very high profile matter, it will be police prosecution as it is in this case, even though Minister of Information wants us to believe that it's a high profile matter. The prosecution is being carried on by the police. They will tell you that because investigations are still ongoing, the court should even not grant bail. Normally. So the rendition is that investigations are still ongoing. And indeed, there's no time bar to investigating a crime. I am sure we are in the media, so you ought to have heard that about 3 weeks or so ago, somebody who had been jailed for 15 years had just been released for wrongful conviction. I don't know whether you heard that he had been wrongfully convicted. You know, and that the actual culprit had just been found. So it happens. But for further investigations, I don't think this would have happened. So whether or not a matter is determined and a conviction is carried and sentencing done, the police still get the opportunity to go beyond and investigate the matter. So if they find contradicting evidence or evidence pointing to another party, they'll bring the person before the law courts. So it's not sufficient for the Attorney General.
Roxy, you're not saying that, look, at the moment, let's just jail anybody until such time,
not at all. Not at all. I am only stating a principle, a criminal procedure principle. So even though the police are often will want to proceed with a matter, they will let the court know. Once the offender is more than one single person, it means one or more abetted, one or more conspired. So they still will go deep down and investigate the matter. So if there are more offenders or more conspirators found, they will be brought to book. So they will normally will tell the court that. Okay. Now, the principle is this. If you do not have sufficient evidence, you don't even arraign the people. This matter, based on the principle that is being stated, it ought to have died at the police station. Because for a policeman to arraign you before a court of law, it means he has, through his investigations, he has been able to establish a prima facie case. A prima facie against you. Sufficient for him to at least prosecute his case before the court. Now, when that is done, the court also must come to a determination whether or not a prima facie case has been made against you to warrant you to open your defense. So, if you have a defense lawyer who is smart, who is on top of his case, and who has followed the proceedings of the prosecution carefully, and who has done an effective cross-examination at the time that prosecution opens his case, can make an informed legal decision that the prosecution has not sufficiently made a case against you to warrant you to open your defense. That is, to also state your side of the case. So he will be making what we call a submission of no case. And the court will have to rule on it. And when that is done, and the court supports the position of the defense counsel, that ends the matter. So I will be hoping that the state could have done this. That at least the evidence that you found, which was sufficient enough for you to move beyond the point of a mere complaint to one of investigations where you take caution statement, then based on the investigations gathered, you take charge statement. That is why you are told that you are being charged for court. The first caution statement is that a case of so and so and so has been made against you. And so investigations are ongoing. And you are entitled not to say anything, because anything that you say will be used in a court of law against you. And you are entitled to a lawyer. They will tell you all those recitals. That is a caution. Where a charge statement is being taken, they say so and so and so and so case has been made against you. Investigations suggest that a case has been made against you, and therefore you are being charged for so and so offense before a court of law. You are entitled to a lawyer of your own choice. You are not supposed to make or amend. If you are entitled, if you wish to add, to amend, to delete, to say anything to your original statement, you are entitled to do so. And that is a charge statement. You are being charged. So once they move beyond a caution statement to a charge, it means they have gathered sufficient evidence. Now, when you are arraigned, you are in the hands of the court. Okay. Now, let's get back to the principle in question. The doctrine of nolle prosequi.
Before you get there,
yeah.
After the police have submitted everything to the AG, can the AG then look at it and say, no, there's no need me taking this to court because I'm just going to be embarrassed?
Indeed, yes. And I'll explain. It is procedural that in high-profile matters of this nature, the prosecution, which is normally the police, the investigative body, will prepare a docket and forward it to the AG for an advice. Technically, it is called the fiat. Now, the AG must bring, because the AG is peopled by trained lawyers, their level of appreciation of the criminal law is considered higher than those of police prosecution. Indeed, the prosecution is done in their name anyway. So they are asked to give a final decision or direction on the matter. So they would appreciate the evidence that has been gathered at the investigative stage with the thinking at the back of the mind of any state attorney, whether senior, whether principal, whether chief, that investigations are always ongoing in the matter. So, moving from the generals to the specific, my dear Marie Louise Simmons, who gave the advice a state attorney, a senior state attorney, who gave the advice on behalf of a chief state attorney, because the Kumasi office is headed by a chief state attorney in this matter, reviewed the file and came to the unfortunate conclusion that, particularly at paragraph 15, she says that, and she quotes the principle, that there's no better source of evidence than the evidence of identifying a culprit by an eyewitness to a crime. She didn't even state the authority, the sources from quoting this authority, but it's a basic principle in law. Yes, but is that all? Is it on the docket? You see, the inquisitorial mind in her should ask the following questions, and I'll ask them. Have you gathered a statement from the sitting judge, the juristic officer whose court was attacked? She ought to have prepared a checklist. Then she will take. Did you gather a statement from the court warrant officers who were supposed to have policed the court on the day of the attack? Did you gather a statement from the court clerks, the people who sit right in front of in fact, they mentioned the case before the Republic versus so and so before the docket is handed over to the judge to deal with. Those people, those are the court clerks. Did you gather any evidence from them?
Hold on.
No, so I am only stating that the source of gathering hardcore evidence is limitless in this matter, including the court bailiffs and the court interpreters. Because the court was fully packed that day. Journalists were there. People came with cameras to cover the events of the day, because this was the substantive matter was a very high profile matter as well. So the court was populated by journalists, both from the print and the electronic media.
Roxy, could this be the fact that, when these guys were freed and therefore, because of the pandemonium and everything, we are told that the police came out into town and started picking macho men up. So the story is that, look, I was just picked up because I have, bulging biceps. That's why I was picked up. In that case, I mean, what do you go and ask the judge? Look, do you remember this guy coming to court to free them? Or, I mean, well, how do you continue?
No. You see, at this point, the judge is a victim. The judge, because if you recall, the judge was reported the matter to the police, and she was given a medical form to attend hospital. So she herself is a victim in this matter. So she's become what we call a material witness. Whether or not she'll be able to identify these people when they are paraded. But we have even gone beyond the stage of parading, because we have arraigned the people before court. So the basic requirements of identification, we've gone beyond it. It means some persons have been identified as having been the actual culprits. Unless we are still at the arresting stage, then we are saying so some persons should come and identify. If this were happening at the arresting stage, I wouldn't have too much qualms. But we have gone beyond the arresting stage. We have prepared a docket. A suit number has been given to the case. So conduct the matter to its finality, its logical conclusion. The truncating of the matter at this stage is what is sending the antenna of the minority up.
Could this be that maybe the prosecutor, please forgive me, prosecutor, did a shoddy job that the AG can't work with? In this case, can the AG bypass the prosecutor and say, look, I'm not happy with this, and therefore go and do further works and bring it?
Indeed. And it is not the work of the prosecutor in this matter. The prosecutor is not the one who conducts the investigations. There's an investigator in this matter, investigator or investigators. They will do the preliminary investigations and prepare a report, prepare a docket containing all the facts surrounding the case. as well as the evidence as gathered. Then it would have been submitted to the crime officer, either of the district or of the division. That is how their procedure works. The crime officer will look at the docket carefully, and given the sensibilities, the sensitiveness of the matter, and the number of social, cultural, and political sensibilities to be affected if you don't handle this matter carefully, the crime officer will make a decision. He will give the directive that arraign these people before a court of law. So the investigator's job will just be to now, hold on. So he would now arraign. Now when that is done, it is sent to a central pool for a prosecutor to be assigned. So the ACP who is handling this matter, I'm sure he was just assigned the docket from whichever division is in charge. He takes the docket, he peruses it, and says, okay, now we can arraign for their pleas to be taken. After the taking of the plea, so the plea is that, are you guilty? The charges that have been read, are you guilty or not guilty? And I'm sure because they have lawyers and all that, they would have been properly advised. So they said they were not guilty. Then they are admitted to bail if the court is minded. Now, if you recall, they were not admitted to bail on the first day. If you recall, yes, they were denied, they were remanded. Now, the procedure is that when this happens, then the prosecutor in the matter will now direct that when we next appear in court, refer this matter to the AGs for an advice. They always do that so that they are saved. Otherwise, today would have been bashing the police. But now we are bashing the AG's office. So between the time of adjournment and the next date, the docket is sent to the AG's office expeditiously for a fiat. That's the AG's advice. It is this advice that has occasioned the truncation of the matter today. And the advice is, well, the letter was submitted on the 25th of April 2017, and it is reference ASH, that's Ashanti Region Court.16, volume 52/44, dated 25th of April 2017, from the police unit. And sent to, so when my sister, Louis Marie Simmons, was responding, she made reference to this letter, and her fiat was dated 9th May 2017. So it is a fiat containing her conclusions, her exposition on the docket, giving the nature of the evidence before her, and her exposition, and saying that based on the information I've gathered from the docket, do not pursue the prosecution, desist. So technically, they are filing a nolle prosequi in the matter.
You see, just like the minority, when I heard I was incensed, and I'm saying, it's a breeding ground for impunity. Look, like the Jews, just hang somebody, just give us somebody to crucify, because what's going on is just terrible. Shouldn't we take our time and then find the culprits, or are we all jumping to that?
But Nana, I was making the point.
Look, just hang anyone.
No, Nana, I was making the point. You see, these people were not picked from a vacuum. There was an earlier video concerning the substantive matter where they went to attack the said regional security person. And on that video, there were getting to about 40 of them. And anybody who watches this video on a slow motion basis, you can identify everybody. Okay. It was a subsect of these people who were picked and arraigned for causing physical harm, attacking destruction, causing destruction to state property and all, in the Republic versus those 13 Delta forces. Now, it is this case that has attracted these additional 8 from the group from the other members who have not been affected by the the action in the 13. So there's an earlier video where you could pick these people. So I do not believe, for one reason, that these persons were persons who were just picked out of nowhere. They have a causative link to the matter. In any case, as a minority, we are saying, and I'm a lawyer, and the minority leader is a lawyer. The defense lawyer, I've been a defense lawyer in hundreds of criminal cases. But I'm saying there are some of the cases, you don't speak the way you are speaking. You have to speak to dovetail the conscience of the state on the matter. You have to say that, well, this is what the Attorney General has decided. But as defense lawyers, we'll reserve our commentary until further notice. But you don't say that this is a trump for the rule of law. No. Because he knows by his training that there are so many other sources of concrete information the police could have gone to extract.
Oh, but that's procedure. But as far as rule of law is concerned, to the lawyer, if the AG rules, it's rule of law.
No, and I'll come to that constitutional prerequisite. Now, 296, A, B, C, and all that.
Yeah, they entitle you. But what's candid? I mean, my candid won't be your candid.
No.
I mean, being
no, read it.
No, I mean, I know what it says. I mean,
Yes.
see, but it says to be fair and candid.
Good.
But in a criminal trial,
Yes.
you know, my fair and my, I mean, if my son, you know, broke your glass and the judge gave him a caution, I'll say I got good justice. For you, you say the judge was not.
This one,
candid.
justice has not even been done.
No,
You have the processes that will lead to the exaction of justice or administration of justice in the matter has been truncated.
But do we know why the AG says, no, I'm not going to go forward with this case?
And I want to explain and bring in the angle where the Minister of Information has also issued a statement.
Yeah.
I don't know if you've chanced upon that.
She said that the Kumasi AG acted alone.
And it makes the matter very interesting, because when I was speaking, we were being interviewed by another station, Star FM, myself and the Honorable Bribwine. He was supposing that we should wait and assess the certified true copy of proceedings of the court before we comment. He was telling the minority this evening, and I said no. The government should deny the statement that has been put in the public domain since about mid-morning. If they deny the reportage, then would have exercised restraint. But they have not denied the reportage. Indeed, the statement is reacting to the same reportage out of which we reacted. So you see, you don't have to wait for a certified true copy of the court proceedings to make informed comments on this matter. Okay. Now, the Minister of Information
a little education, yeah.
Okay.
Can the Kumasi AG's office look at a case and with their legal expertise, you know, this, you know,
they can do that, and that is my next point. Okay. The AG cannot say. In fact, if she does that, she will be digging her own grave. You can't say that a decision taken by a state attorney in your name, in the Ashanti region, you haven't given your blessing.
No, but this is a high-profile case.
Yes, and I'm saying all the regional attorney general offices are manned by chief state attorneys and all principal state attorneys, because you, as the attorney general, you cannot superintend all these regional offices at the same time. That is why you are centralized in Accra with 2 deputies. But the regional offices are manned by persons that have risen through the ranks to reach where they are. So anything they do, you will see that this document, the letter was signed by Louise Marie, who is a senior state attorney. And she says that she does so on behalf of the chief state attorney, who is the senior most in the Ashanti region. Do you understand me? So if you are now saying that there are internal breakdown in communication, that is your gamut.
I'm just going to take a quick break, and when I come back, I want to find out, could it be because of the national interest in the case, that's why the AG would have wanted briefing quote and unquote, let's say if it was a Wyoming case, you couldn't sit in the region and just decide on the Wyoming case without letting your boss know that, look, this is where we are and this is the decision I'm taking. In law and legal parlance, is, you know, is
yes,
allowed.
and I'll give you instances.
Let me take a quick
yes.
break and then I'll come straight
yes.
back. So we're coming back. Well, thank you very much for staying. And the Delta Force 8 release, the Attorney General in the Ashanti region has looked into the case and thought, look, I don't think I have a case, and therefore I am dropping all the charges. Minority are incensed and saying, nope, you should have gone further. At least let's try our luck in court. Let's see how far we can push this. Minority thinks maybe the case has been cut short prematurely. However, the Delta Force themselves mentioned earlier on that, you know what, we were not supposed to go to court in the first place. So people are there putting two and two together to think, well, if they were not supposed to go to court in the first place, then maybe this is exactly what they were talking about. But before the break and before I come to this, I just wanted to find out if the central national interest in the case, whatever region dealing with such a case, should you be, you know, liaising with your boss to say, look, I've looked at the case and this is the decision I'm going to take, rather than just take it?
Now, Nana, you raise a very valid question. Given the AG's office has a way, or the police, they have a way of gauging the national mood anytime there's a matter that offends the greater sensibility of the people. And I can cite one example, the Afoko case.
Yeah.
The offense must have been committed in up north. But given the sensibilities involved, they ordered that the trial be held in Accra. And so Afoko, the accused person, was transported to Accra and kept under close watch. So the proceedings is centralized, and the AG, as it were, will have a close monitoring of what is going on. That is what you do. This is a matter that has attracted a lot of national attention. So if I want to believe that if she had done that, I don't think this would have created the kind of problem it has for her. For her to say that I did not authorize Marie-Louis to sign this, or I didn't authorize the office to do this on my behalf, because Louis signed on behalf of the existing chief state attorney. But the more important point is that we are not crying because a nolle prosequi has been filed simpliciter. We are saying that given the nature of the people involved and the nature of the offense involved, nobody ought to be allowed to go home free when the person is suspected to have gone to attack a sitting court.
But then there's nothing like a no bailable offense.
Sorry?
There's no such thing as no bailable
offense. No,
offense.
the law has been refined. So we are not saying that they should not be bailed, but we are saying that allow the adjudication process to be exhausted. Let them go through the mill. Let the matter be determined on its merits. Let evidence be led.
You see, that's why I'm worried that maybe we are being premature
without
looking at...
we are not being premature. What has happened has happened. They are not denying that they filed a nolle prosequi.
No, but the reasons why they filed, it's not clear to us.
When you file a nolle prosequi, you don't have to give a reason. Hold on. You don't have to give a reason. I agree. That is why, for instance, when the matter is one of murder, the charge is one of murder, and the evidence is that the accused was seen supposedly holding the head of the deceased person, the state can still decide that we will enter a nolle prosequi. It doesn't mean that you don't have sufficient evidence. You are only saying that I am no longer interested in pursuing the matter. That is the principle. Whether you have sufficient evidence or not, when you file a nolle prosequi, it does not mean that you are doing so because of lack of evidence or the sufficiency of it. You are only saying, I am no longer interested.
Oh, but that would mainly be based on the fact that if I go, I will lose.
No, that is not the principle. The principle is that the state, the republic, is saying that this matter, this criminal matter, I am no longer willing to pursue it.
As in pick and choose which ones to prosecute.
It is not about pick and choose. It's a common law jurisdiction that we have inherited. Whether its application or it's the discretion to exercise that power
to file a nolle prosequi.
Yes.
The AG is just decided that, look, today is Wednesday, I just not feel like following this case anymore.
Yes, but I will tell you why. And I will tell you because if you read Article 296 carefully, it's the power to do so is one of discretion. Now, discretion has been severally defined by our Constitution.
Do you think it's politically motivated, this decision?
That is the exact point we are driving at. That if it were,
it's not a coincidence that, listen,
no.
There's no interest.
There's no coincidence. There's no coincidence at all. There's no coincidence. Why haven't we filed nolle prosequi in the case of the Chinese galamseyers? Why haven't we done that? So it is not a matter of coincidence. It's a matter of deciding to exercise a power that's been granted.
I'm sure the AG has filed many nolle prosequi.
I agree.
Maybe there are no political coloration, so we haven't followed it.
No, I agree. But we are saying this one, we are saying it was considered, it was applied on grounds of politics. Because the people who have been positively affected by it are unquestionably MPP activists. Unquestionably. And the point was made right from the beginning that these people should be freed, even though it happened. Top-ranking MPP persons made these remarks in the media domain. You can go back and check. So we are only saying the decision dovetails to those remarks that have been made. And if you look at the interviews that a lot of them have granted, ex post facto the events around the court premises.
One sec. Let's get. I'm going to have a sound bite. Let me just hear the sound bite.
At the emotional issues you have raised, and of course, even the national concerns that followed the events of Delta Force. When you enter the realm of legality and the law, you don't go raising moral and emotional matters in that nature. Let us not also run down our institutions because we disagree with a judgment or we disagree with a particular decision of the AG. I have been in several cases where judges have grudgingly discharged accused persons because there was no evidence. And the moment you go to court, it is a question of fact and evidence. If you cannot bring up an evidence to prove your case beyond reasonable doubt, then there's no point wasting the court's time to start the processes of prosecution. And we know, per our Constitution, go and read Article 19. It tells you that an accused person is innocent until he's proven guilty. If you read the Criminal and Other Offences Act, Act 30, and then you read Act 29, the Criminal and Other Offences Code, the Criminal Procedure Act. The Criminal Procedure Act and the Criminal Code, they all tell you that the onus of proof, and then when you read our Evidence Act, the onus of proof in a criminal trial lies on the prosecution. And the accused person ought not say anything to prove his innocence. So if you are a police officer doing your investigation and you talk to potential witnesses whom you are going to call, and it's a question, the critical thing here is identification. 8 people whom you have arrested and accused of causing a particular crime. And in your evidence, you write that you are unable to identify or to confirm that these were the people you saw committing those acts. Then what would be the basis of the trial? So let us put sentiments aside and deal with the legality. And how will any prosecution on earth go there and say that we suspect? It is only on mere grounds of suspicion. You understand? And this is the docket presented to court. So don't deal with the outside hearsay evidences or hearsay media stories you have heard. Once you enter the realm of court, we deal with matters of evidence and fact and law.
Thank you very much. So I just go straight. That was John Kuma, who's a lawyer and also leading member of the MPP. Now, what he's saying is that, look, all these things we are showing TV doesn't matter. You can't use it in court. Is he right? Or?
John may be right because he's a defense attorney in the matter. But we are saying that the issues he raised are at variance because he completely misunderstood the burden upon you to meet the standards as in law in terms of the proof of the evidentiary burden vis-a-vis the raw application of arbitrary discretion of power. Now, when he said that the burden is on the prosecution to prove their case, yes, but you can only do so when you go through the process.
No, but
no.
But I have to go. You see, the AG has to go.
I gave you a background that all that the burden on the police to arraign the suspects before court has been established. They met that burden by making a prima facie case at the point of investigations.
But they don't decide that. The AG decides that.
Hold on. What happened was they arraigned accused persons. So why did we have the court in the matter?
Okay, just for the layman purposes.
Yes.
So I'll make you the policeman. I'm the AG.
Yes.
So you suspect my camera lady
so let
and
me
my
take
cameraman.
you through the procedure again.
Briefly. You suspect my camera lady and my cameraman. You do everything and you bring it. And I look at it and I said, cross rocks.
At what point did I bring it to you?
Well, after you went to arrest them.
No. After arrest, I investigate. After the investigations, my superior, who is the crime officer, will give me the okay to arraign. Arraignment is to bring before court on the charges.
Still, I can still look at it and say, look, we still don't have a case.
Hold on. There are some of them, they send the docket before arraignment. There are some too, they arraign, and whilst the trial is ongoing, when the trial is ongoing, sometimes you just take a date, you just take adjournment, pending the outcome of the fiat. So the arraignment is that. So before I arraign, before your plea is taken, these are the charges. It is read. Are you guilty or not guilty?
So at the point, are you trying to establish that at that point, the AG had no right to say this case is not good enough?
No, I am not saying so. I am only saying it is not right to say that. You will not be correct when you say that the police couldn't have gone to court without the evidence they have. The evidence was sufficient. They met the basic standard of arraignment. Now, when they arraign, the AGs must decide whether or not the evidence that they have is not sufficient for them to actually successfully. The AG will always be looking from the perspective of successful prosecution. Successful prosecution means you must prosecute and ensure conviction.
Without
losing the case. Your advice is that when we pursue this case, eventually we will lose it. The person will walk free. That is the perspective that the AG will be looking at the point that... So
that's what my whole question is. Could the AG have looked at the thing and thought, look, we don't stand a chance because of this loophole, that loophole, they would walk?
Yes, but we are saying that given the nature of the crime in question, the AG cannot be speaking like that because there was a video coverage. Even if it is only one person out of the lot who you can hold firmly to it, would have been sufficient.
So aren't we just looking for somebody to crucify rather than...
We are not looking... We are saying, the minority, we are saying that the power to exercise this discretion has been abused on grounds of political expediency, on grounds of not being candid with the fact that they lack evidence, on grounds that the due process of determining, of eliciting concrete evidence to prosecute the matter has been truncated. So it's been abuse of due process. We are also saying that the application is capricious. The decision to apply this doctrine, the nolle prosequi, has been capriciously exercised. And it is not in the interest of anybody in this country that a people who gather, who conspire to attack a sitting court of law in the course of exercising its rightful adjudicatory powers.
So now that AG is saying that, look, I didn't authorize that instruction, can she then recall the case and say, look, I'm
in
taking
fact,
it off?
that if you read our statement, that's our demand. We are saying that because it's a discretionary power, it can be withdrawn, it can be reversed. They should reverse the exercise of that power, rearrest the people, rearrange them, and let them go through the due process of law in the trial. If the court, a court of competent jurisdiction, finds them not guilty, why not?
Will the minority be happy? Aren't we going to come back to the same table and say...
No, if it's a court verdict, we will have no qualms about it. But until the court makes pronouncement, a political officer who is occupying a public office cannot fairly apply this principle and tell us that they are simply declaring the unwillingness to prosecute their matter to everybody's satisfaction in this country. When we do that, we are asking that I should also tomorrow go around and mobilize forces, go and attack, for instance, the Supreme Court judges and walk free. Because I also expect that when I am arraigned, no prosecutor will be entered in my favor. But that cannot be. It will be a recipe for disaster in this country.
Well, all too soon, that's what time will allow us. Time flies when the conversation is interesting and in-depth. And my guest today was Roxanne
Dafamako. Roxanne Nelson Dafamako,
who's a ranking member in Parliament for Constitution and Legal Affairs, and also honorable member.
And a member of the Judiciary Committee as well.
Judiciary Committee, and honorable member of Parliament for South Dai.
Picky and its environment.
See, I have to come and visit your constituency. 024-366-2001 Tantees Fashions. They make my shirts for the show. 024-366-2001. Give them a call. Get yourself a nice shirt for yourself. And again, once again, to all my new fans up north, Tamale and Bolga. I'll see you soon. I've really enjoyed my stay there. And tomorrow we'll be back to do this all over again. Thank you very much for watching. Thank you.